Now, just this morning, Uddhav Thackeray held a press conference a day after the Supreme Court setback. He has dared a legal move again. The relief to this present government is interim, is what he said. The Speaker should decide on the matter at the earliest. If he gives any wrong decision, we will again go to court. This is the latest coming in from Uddhav Thackeray at that press conference that he held just a few minutes ago. Going across to my colleague Vinaya Deshpande, who brings us more on this. Vinaya, is the ball now in the Speaker's court? Why does Uddhav Thackeray expect that the present Speaker is going to take any concrete steps?
Yes, if you look at the judgment that was passed by the Supreme Court yesterday, the ball is clearly in the Speaker's court now with respect to the disqualification of 16 MLAs. Now, whether there's a timeline to it, whether the Speaker can take the call on it as per his discretion is something that we'll have to look at the order copy. Clearly, there has been no time frame to it, but the Supreme Court has also said that whatever the decision of the Speaker will also be open to challenge in the court of law. And that is exactly the point which now Uddhav Thackeray has picked up on. He has said not only should the Speaker decide on the matter at the earliest, but in fact, in case if they feel that this is not in the right direction, they will also approach the court against the Speaker's decision. Now, this is germane to the judgment that came yesterday, and this is on the basis of that very judgment. In the very same press conference that Uddhav Thackeray held just a brief while ago, not only has he said that he will go back to the court after the Speaker takes a decision on the disqualification of 16 MLAs, but he has also sought rules on the basis of which governor can be chosen for a state, because remember, for as long as Bhagat Singh Koshari was the governor of Maharashtra, there were continuous rumblings between the Mahavikas Aghadi government then and the governor, and even after the Mahavikas Aghadi was thrown out, there was a continuous pinching kind of criticism of the governor. So now, after the Supreme Court verdict has given extremely scathing comments on the role of the governor and the way he took steps, which also led to the repercussions after the downfall of the Mahavikas Aghadi government, there have been two major demands by Uddhav Thackeray. Firstly, that the Speaker should take action as soon as possible on the disqualification of 16 MLAs, and secondly, that the governors, that the appointment of governor should be bound by some rules. Now, remember, the Speaker himself is on a trip to UK. He will return by day after tomorrow, and he has said while speaking to us that after he returns, he will take a call on it as soon as possible. Back to you.
Vinaya, now, while the Supreme Court came down heavily on the governor, they also spoke about the actions of the Speaker. They called it illegal when he constituted Gogavle as the whip of the party. Now, taking that into account, considering his actions were illegal but status quo still remains, even if the decision taken by the Speaker now is still illegal, what are the chances that Uddhav's faction has in legal terms?
Well, the most important point there, Shilpa, is yes, as you mentioned about the whip, because remember, the official whip of the party is Sunil Raut and not Bharat Gogavle, as the Supreme Court has mentioned. Now, this in some sense has also saved several MLAs, including Aditya Thackeray, from the aches of disqualification, because remember, it was this very other whip who had issued orders, and that is why Eknath Shinde had claimed that disqualification can be brought against those MLAs who are in the Uddhav Thackeray faction. Now, if you look at the whip issue, it will clearly be applicable. We'll have to see once the House assembles for the monsoon session as to how that plays out. But clearly, with respect to the decision on the disqualification of 16 MLAs, it will be the Speaker's discretion alone. And that is why we will have to wait as to what decision Rahul Narvekar takes, because even after that decision is taken, whenever it is taken, remember, he's not bound by law with any time frame by which he should be taking that decision.
Vinaya, I request you to stay with us because we're currently also joined by Mr. Swapnil Kothari, senior lawyer. Very good morning to you, sir. We were just discussing with my colleague the kind of legal repercussions of Supreme Court's ruling yesterday. Now, the relief that came into Uddhav Thackeray by way of those observations and the fact that the governor and the Speaker was severely criticized. Does that mean that Uddhav Thackeray has a better legal standing now and that he could get relief if he were to take this up legally?
Well, the answer to that is no, because that's a presumption that the Speaker will not act judiciously. And what Mr. Thackeray is saying by this is that the Speaker should be ruling in his favor. The Speaker should be ruling in favor of the party that is right, whether it's him or whether it's the Eknath Shinde faction, depending upon the facts and circumstances of the case. The governor was criticized yesterday because the governor acted on some of the materials that were there before him, which the court thought that they were not fit for him to take a decision. On another day, that decision could have been different by the Supreme Court, because the material that was there available before the governor and the scenario that was prevailing at that time could jolly well have prompted any governor to do what he did, that maybe call for a floor test. Now the fact remains that he called for a floor test, which the Supreme Court objected to, saying that he should not have done that because he did not have adequate material, and his inference was wrong that the Uddhav Thackeray faction was losing the party confidence. So that is the opinion of the Supreme Court, which is fine. No problem at all with that. On another day, it could have been different. But the fact remains that the floor test was not taken and there was a voluntary resignation. And the Supreme Court directed the Speaker to decide the true whip within a reasonable period of time. It did not specify a time frame. Now, it's for the Speaker to decide when he wants to do it. It's for the parties to tell him, especially Mr. Uddhav Thackeray, that please do this at the earliest. There is nothing wrong with that. At the end of the day, if the Speaker's decision is wrong, it is subject to judicial review. That is what the court has said, because the judicial review is it's a basic structure, forms part of the basic structure of the Constitution. Just because the Speaker takes a decision doesn't mean that that decision is a gospel truth. Either way, whatever decision he takes, I'm talking law. So the point is that the court is trying to simply say with that you have the powers to do it, just as the Election Commission has the powers to decide upon the material available as to who the symbol belongs to. So as the Supreme Court said, that these are constitutional functionaries with responsibilities that are important, and that the court is presuming that they will function in a constitutionally appropriate manner, and they will follow the doctrines of constitutional morality and proportionality as well. So the point is, the short answer, after giving you a detailed explanation as to what the whole judgment entailed, is that definitely any party which is aggrieved by the Speaker's decision when he takes it, as and when he takes it, has the power to go to a court of law, and the court of law will be able to review that. So it's not something new that the Supreme Court has stated. It's just in conformity with the facts and circumstances of the case that the court has reiterated what was the earlier position. So the Speaker's decision was never out of judicial review. It was always within judicial review and subject to judicial review. So that is the short point of it. Or naturally, I mean, any aggrieved party is entitled to take a call. Likewise, if any party which is aggrieved by the decision of the Election Commission can equally do so, can equally knock the doors of the court.
So thank you very much for breaking that down and explaining it to us at length. Now, the Supreme Court order on Maharashtra government yesterday said that the governor and the Speaker erred in their processes, but that the court also has not restored the Uddhav Thackeray government as he resigns. CNN News18's political editor Maria Shakil spoke to Maharashtra Assembly Speaker Rahul Narvekar on the same. Take a look.
Talking to News18 before the big Supreme Court verdict, you had said that only the Speaker can decide on the disqualification of MLAs. Now, Top Court 2 has ordered that you would take the final call on the disqualification of 16 MLAs of the Eknath Shinde camp within reasonable time. By when? We shall expect your decision on the issue, because the current House is nearing its 4th year.
Well, like I had said it earlier, the Supreme Court has rightly recognized the powers and the duties of the Speaker of the Legislative Assembly to adjudicate issues pertaining to disqualification in accordance with Schedule 10 of the Constitution of India. This is, in effect, recognizing the constitutional discipline that needs to be followed. In our Constitution, we've got the executive, legislature, judiciary, which are the three wings of the Constitution, which are equal and neither have superintendence over the other. And they are required to act within their scope of jurisdiction of work.